各位陪審員，
Before you hear the evidence in this
你喺
case,
聽呢
I'm
個
going to
案
spend a few
件嘅
minutes
證據之前
explaining
呢，
some
我
basic
想用幾分鐘
principles
去解釋啲
that
基
will
本
be
原則，
important for you in deciding this
佢會
case.
對你去決定呢單案件係好
I
重要
also
嘅。
wish to explain a little
我都
further
想再多
what I
啲解
expect
釋
will happen during the course of this trial.
喺呢個審訊期間會發生啲咩事。
I shall begin with some general comments on the judge
我
and
會
jury
解釋
system.
翻一啲法官同埋陪審
This
團
system is
嘅
one of the
體
oldest
系
and
啦。
most important
呢
of
一
our
個
legal
係
traditions.
我哋司法系統最悠久，亦
It
都
is a
最重要
team
嘅一環。
system
佢係一
where you
個
are the
合作
judges
性
of the
嘅
facts
體制。
and I am the
你
judge of the
係事
law.
實嘅裁判者，我
Each
係
of
法
you
律
has
嘅
been
裁判者。
selected for this trial
你
as a
哋
judge
每一
of
個
this
人都被
court
遴選出嚟
with
做
responsibility
陪
over
審
the
員
facts
嘅。
of this case.
你哋就係肩負住裁決本案事
Just
實
as when I
嘅
was
職責。
appointed to and undertook my duties,
當
I
我
was
就職
sworn
宣
into
誓嘅
office.
時候，我都
You
好似
have
你
taken an
咁，
oath before you embarked on your task as a juror in this case.
亦都係要履行陪審員
You
嘅
are
義
for
務。
this trial judges of this court with the exclusive
你哋係
responsibility
呢一
for
個法
assessing
庭嘅
and
法
reaching
官，
conclusions
你
concerning the
哋有
evidence.
責任去進行呢個證據評估
By the same
同
token,
埋作出結
When I
論
tell
嘅。
you what the law is,
相對地，
my view of the law must prevail.
我對法律嘅見
I
解
am the
係
exclusive
有
judge of the
決定
law
性嘅。
with
我
exclusive
係法律
responsibility
嘅唯一
for
裁
that
判
for this
者，
trial.
亦都只
It would be wrong
對
for
此
you to
負上
decide
絕
this
對嘅
case
責任。
on the basis of what you think the law
你唔
is.
可以用你對法律嘅見解去決定呢一單案
There are
件。
two other basic principles which are fundamental to your role as jurors.
作為一個陪審團，亦都有
They
兩
are
個基
the
本原則
requirement
嘅。
for proof
第一個
beyond a
就
reasonable
係
doubt
無
and
合
the
理疑點
presumption
嘅
of
證明，
innocence.
第二就係無罪推定。
The requirement for proof beyond a reasonable doubt means just what it says.
無合理疑
No
點
person
嘅證明
accused
就
of a
係書
criminal
面
offence in
嘅解釋
Canada
啦。
can be found
咁
guilty
喺加拿大
unless the Crown
指控嘅
proves
罪
each and
項
every part or element of that offence
每一個構
beyond
成
a
嘅元
reasonable
素咧，
doubt.
都要達到無合理
Similarly,
疑點嘅
our
證
system
明。
of
如果
law
唔係就會被
requires
判無罪㗎
that
啦。
an accused person be presumed
同
or
樣地
considered to be innocent.
我哋法律體系要求被告咧係一直無罪，直至
Has
證
no
明有罪嘅。
obligation to prove that
Brian
he is
Peter
not guilty
Davison 咧，亦都
or
唔
to
需要
explain
去
the evidence
證
offered
明
by the Crown.
佢點解無罪，亦都唔需要
The
向
law
證物去解
presumes
釋
him to
嘅。
be innocent until you, as the
法
triers
律
of
都係
fact,
一直
decide
會話佢係
otherwise.
無罪，直至到你哋所謂事實嘅裁
What does
決
this mean
者
to you as jurors?
作出相反嘅裁定啦。
First,
對
it
呢
means that the
一
law
樣嘢對
requires
住
you to
陪審員
decide
意味住啲咩
whether
呢？
the accused is guilty or not
第
guilty.
一，
Based on a
被
careful
判有罪
consideration
或者
of
冇
all
罪
the
呢，
evidence you will hear in this
你
court,
首先要聽取晒所有嘅證據，先至可以進行判決。
Second,
第二，
the requirement for proof beyond a reasonable doubt
無合
and the
理
presumption
疑
of
點嘅
innocence
證明同埋無
mean
罪
that you
推
must
定嘅
pay
要
close
求，
attention to the
就話
evidence,
你一定要去
because you
細
can
心
only
去
return a
睇
verdict of guilty
啲證據，
if you are satisfied that
因為
each
你
element
判
of
佢
the
有罪
offence
嘅時候，
charged is proved beyond a reasonable doubt.
係唔可以有任何
If
懷
you are
疑嘅程
left with
度。
a reasonable doubt after you consider
如
all of the
果
evidence,
你係有任何
you
嘅
must
懷
give the
疑，
benefit of that doubt to Brian David Patterson
所有疑
and
點就
return a
歸於
verdict of not guilty.
Brian David Peterson，而判佢無罪。
When I finish these remarks,
當我講完之
I
後，
will call upon Mr. Berger, the lawyer representing the
我
Crown.
就會叫檢方代表律師 Mr. Berger 去做開場陳述。
Mr. Berger will tell you what he expects the
Mr.
evidence will
Berger
be
會説明
and what he expects the various
唔同
Crown
嘅證
witnesses
據
will say.
同埋佢呈現
The
嘅證
purpose
據
of this
內容。
opening statement is to make it
開
easier
場
for you
陳述嘅
to
原
follow
因
the
就係等
evidence
你
as the
容易啲
witnesses
去掌
testify.
握證據，
It is important, indeed,
好
critical,
重要嘅，非常
that you
重要。等你
understand
明
that
白
the opening statement of
開場
Crown
陳述
Counsel is not
檢
evidence
方嘅開場陳述係
because it
唔
is
係
not
證
given
唔係
under
證
oath
據，
by a witness from the
因為
witness
佢唔
box.
係喺證人欄裏面證人嘅
Opening
證詞。
statements are given for a very
開場
specific
嘅
reason.
陳述係有特別嘅原因嘅。
The evidence in a trial such as this is not a narrative that unfolds chronologically and
呢
sequentially
個證據呈現
like
嘅
a
方式
book
就
or
唔
a
係好似
TV
本
play
書或者
or a
戲
movie.
咁係順序嘅，因為佢係唔順
Witnesses
序。
are called who testify as to what they
證
know
人嘅
about
證
a
詞
particular series
係
of
話翻俾我
events.
聽佢哋知道嘅
In
事
many
實。
respects, it is like a jigsaw puzzle,
呢
with
個就好似
witnesses
拼圖咁
testifying
樣，
as to
每一
particular
次
areas that they
有
know about.
證據嘅時候
so
呢
that you can
就
understand
你
the
就
whole
可以將
picture.
啲信息片段將件事還原啦。
Is so you can have an overview of that evidence.
呢一個開場陳述係等你有呢一個掌握證據嘅框架，等你可以容易啲明白整體係發生緊咩事。好重要嘅，你要明白到檢方嘅開場陳述就唔係證據。證據呢，一般都係證人席嘅證人嘅證詞，或者係呈上法庭嘅證物先可以做證據。當 Mr. Berger 講完佢開場陳述之後呢，佢就會傳召第一個檢方證人，佢就會開始主問證人啦。主問證人係一系列嘅問題，俾個證人有機會話俾佢聽，話俾你哋聽發生咩事。主問期間，律師係唔可以問一啲有引導性嘅問題。引導性嘅問題係可以被反對嘅，因為就會係律師作證，就證人只係答同意或者唔同意。當 Mr. Berger 問晒問題之後呢， Mr. Darrow 亦都有機會去盤問證人。好似主問咁樣，盤問亦都係一系列嘅問題。盤問嘅原因就係檢驗證人嘅證詞，亦都可能揭示有利於被告嘅事實。律師會問問題，去檢驗證人嘅可信度啦、觀察能力啦，或者記憶力。佢可以唔問任何問題，或者盤問係可以問一啲有導性嘅問題。當 Mr. Darrow 完成盤問嘅時候呢， Mr. Berger 可以再次主問證人，如果程序中間有新嘅事實。呢個程序會繼續，直至到檢方嘅證人作證完畢。當控方完成呈遞證據 ，Mr. Darrow 可以代表佢當事人提出證據。如果辯方選擇傳喚證人，咁控方證人一樣有同樣嘅程序。呢一次 ，Mr. Darrow 就會係主問 ，Mr. Berger 就會盤問。當被告決定提出證據嘅時候，控方有權提出反駁證據。如果咁發生的話，個程序就會好似控方案件嘅第一部分。